Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam. I'm Matthew Hall. The 2024 edition of the ABA Antitrust Law Section's spring meeting in Washington, D.C. offered the Our Curious Amalgam team a chance to speak with competition law regulators from around the world. We asked several of them to discuss their enforcement priorities and other issues with us. Today's episode is What's Happening in the EU? A conversation with DG Comp Director-General Olivier Guersent at the 2024 spring meeting. I spoke with Director-General Guersent for this episode, which is his third appearance on Our Curious Amalgam, following previous episodes 165 and 229, recorded at respectively the 2022 and 2023 spring meetings. DG Comp, based in Brussels, is responsible for the European Commission's policies and enforcement of competition and antitrust law. As such, it is the lead competition regulator in the EU. The Director-General is the most senior permanent staff member within DG Comp, reporting directly to the Commissioner for Competition, Commissioner Vestager. In the next 45 minutes or so, you will hear our wide-ranging discussion about the recent and upcoming work of DG Comp on merger control, antitrust, state aid, Digital Markets Act, and foreign subsidies regulation enforcement for the EU. Director General, welcome back once again to Our Curious Amalgam here at the spring meeting.
Always a pleasure.
What would you identify as the key decisions or other developments for DG Comp since we last spoke here at the spring meeting in March 2023?
Well, maybe I'll take two developments and a decision. The two developments is first the DMA, the Digital Market Act. I mean, I think I don't need to explain what it is. It's well known by the time. So it came into force in July last year. But we had a long implementation phase before it was actually enforceable on March 7. So during that phase, we have worked with what we call the gatekeepers, so the various platforms that have been designated for their kind of super dominance as gatekeepers in order to, first of all, identify which are the obligations and prohibitions they have to comply with. Secondly, to see with them whether they were already compliant, in cases that was the case, or if they were not, how to become compliant. And we did this, we had a constant feedback loop with the companies, but also with the third parties, the customers, the business users, and the consumers. And this feedback loop we operated through workshops. So at each stage of the process, problem definition, mapping, and testing of the solutions put forward by the incumbents, we had these workshops with the feedback by the market. So that worked quite well, and that requested quite a lot of commitment and involvement from the gatekeepers, because if you think about it, that means, first of all, having to rethink, in many instances, your business case and business strategy. And once you've done that, you need to adapt your coding, and you need to adapt your legal. We're at the ABA, so all the contractual obligations, the relationships with the various parties, all of this had to be redone, to be put in line. So that was quite big. Of course, it didn't go as smoothly as we would have liked, and various point of views, we disagreed. But in the end of the day, out of the 6 gatekeepers we designated and 22 core platform services that they operate, we ended up having 5 non-compliance procedures that are ongoing at the moment against 3 companies, Google, Meta, and Apple. So Apple and Google have each 2 non-compliance against them. So that is really a significant development, and it will continue to be, because we want the DMA to be a success. Therefore, we want the gatekeepers to comply, and we want the consumers and the business users to see an actual difference.
These non-compliance investigations were started very soon after Compliance Day, also even before the compliance workshops. Was that deliberate? And do you think that despite all that work in the past, there's a bit of a confrontational position now with regard to some of these gatekeepers and what they are or not doing?
Well, yes. I mean, and I think that 5 non-compliance out of 22 platform services and a huge number of do's and don'ts, obligations and prohibitions, it's kind of moderate. Of course, 0 would be ideal. I mean, the goal is not to have non-compliance procedures. The goal is that they comply. But if you think about why we have the Digital Market Act, we have the Digital Market Act because repeatedly for 25 years, we have sanctioned the same behaviors, and repeatedly they have reiterated. No matter how hefty the fines we were imposing. So the DMA is meant to put an end to this. And
the Commissioner has been quite strong on some of this, apparently saying that some of the gatekeepers are deliberately trying to scare away some of the third parties.
I think that is true. That is true. That is absolutely true. And we're not ready to tolerate that. So as soon as we had a body of evidence that in our view was sufficient to trigger high suspicions of non-compliance, we launched the investigation without waiting.
What about the security side? I know that Apple has made a lot of noise about security issues with side loading and that kind of thing, and the Commission actually started a study on security. Seems quite late in the day, in late 2023. Was that something you'd always thought, or you were kind of bounced into doing that?
No, I mean, it was clear from the beginning. This is a big part of the conversation when we were in the making of the regulation as well. Because the gatekeepers, but in particular Apple, has always been coming with this. I mean, basically, the flip side of opening is compromising security, if I simplify. That's not really new. I mean, my previous job was to be responsible for financial regulation in the EU. And when I was doing that, I had to force the banks to open their apps, their API, to third parties, so that, for example, people could create apps in which you could locate all of your bank accounts and do not have to go on the app of one bank and the app of another. And what did the bank say? Oh, God, it's terrible. I mean, you're drilling a hole in my cover, and the security of my data will be compromised. Of course it was not. But you need to be careful with these things. But there are ways to have end competition and security.
It's interesting you see a parallel there.
I do. So that was the first significant development, and it will continue. If we see each other next year, I can tell you it will continue to be a significant development. The second very big development is the foreign subsidy regulation. It's important to understand, especially for an American audience, what is the foreign subsidy regulation. We have in Europe a control on state subsidy. That doesn't exist in most of the other jurisdictions.
The state aid rules.
Yeah, the state aid rules. That doesn't exist in the US in particular. But we think it serves us well. It's also linked to all the idiosyncrasies. We are one single market, but we are 27 different states. So you need to have a set of rules that is a bit more than the anti-subsidy rules of the WTO. But for 70 years, we've been applying a control to state subsidies to our member states, but not to foreign jurisdictions. So in other words, where, I don't know, France or Germany was giving an aid to a French or German company, if a third-party jurisdiction would grant the same type of aid to the same type of company within the single market, we had no authority. And that was clearly a gap in the enforcement cover. So we decided that we should cover for it. So there are 3 pillars in this foreign subsidy regulation. The first one is about subsidized bid in public tenders. The second one is about subsidized acquisition in mergers. And the third one is about everything else. So in other words, large operational aids to companies in order to maintain them artificially on the market and allow them to practice dumping against their competitors. We have launched already a couple of investigations, and interestingly, so far at least, when we have open procedures, the companies withdrew. So we'll see whether it's a pattern that continues. But we opened a new proceeding yesterday against subsidized windmills. But that is quite important. But two things are important to know. First of all, it doesn't overlap with WTO or trade rules, because as soon as a subsidy is within the WTO perimeter, it is not a foreign subsidy in the sense of the regulation. And secondly, it does nothing else but to create a level playing field between our member states and foreign states. So it's not a kind of disguised protectionist device. So we'll see how it will work. It will be challenging, of course, because I can tell you it's challenging to control state aids by our own member states. So state aids by foreign jurisdictions is going to be even worse. But that we think it's really important.
And certain foreign jurisdictions, or at least one, has been complaining a lot about this. The most recent investigation you mentioned, the China wind turbines, is an ex officio example. Then there have been two concerning public procurement cases, solar parks in Romania. Mm-hmm. Each of those involves Chinese companies. And then the one you mentioned where they've dropped was public procurement again involving trains in Bulgaria, and again a Chinese company. The Chinese Chamber of Commerce to the EU, which has been very vocal about this, they've made a lot of extraordinary comments, referring to this as economic coercion, unfair, discriminatory, not transparent. What's your reaction to those comments from the Chinese Chamber in Brussels?
Well, it is very transparent. It is not, I want to be clear, it's not an anti-Chinese device. We catch whoever transgresses our rules. And if they are Chinese companies, they are Chinese companies. But it's certainly very transparent. It is very fair because we simply act the way we have been acting for 70 years against our own member states. So we don't really, and finally, I'm not sure it's not such a treatment that is worse than the treatment all companies receive in China. They complain also, by the way. So, no, I mean, we think this is the correct thing to do. Tomorrow it may be American companies, it may be, well, any other company. Of course, some jurisdictions tend to give more subsidies than others.
Yeah, they're pointing out that of the first 4 investigations, each of them involves Chinese companies. So maybe that's not surprising their reaction, even if it's arguably incorrect.
My third point is there is a decision that I think is specifically important in terms of shaping the future. And that is the decision we took under our merger control regulation rules against Booking. Booking is a platform for hotel reservation. I think most people know that. And they were willing to buy another platform that is specialized in the reservations that's called eTravelI. And what is interesting here is that this is, this type of strange animals you see mostly in digital that we call non-horizontal, because it's clearly not horizontal, it's not really vertical. And conglomeral in the sense that it used to have is not either the right word to characterize this. It's actually mergers, companies that are active in markets that are part or could be part of a single ecosystem. And what is interesting is that for this type of things, normally you have, several things could happen. You can monopolize an adjacent market to the market in which you're dominant. But you can also simply use the merger in order to raise barriers to entry into the market from which you derive your power, your core market, as we call it. In that case, what is really interesting, everybody said, that's very, very innovative, etc. What we call entrenchment, so raising these barriers. I don't think it's so innovative, to be frank, but it's certainly new. But in that case, what was really interesting is that by the own admission of the parties, this non-horizontal merger would have resulted into an addition of market shares. And that's interesting. Now, normally, non-horizontal merger do not result
in the core market.
In the core market. So that means that by buying and integrating this e-Travelite, they were expecting the market share to move from 60-something% in Europe, say 1.5 to 3% up.
Which was enough for you?
Well, our test is small but significant. We think it's significant. If you're already quite dominant, above 60% market share, an addition of 3% is certainly significant. Anyway, and why is it that this happens? There, the internal documents of the companies were quite interesting. It's because we're stupid. Well, they don't say that. They say it's because we're sticky.
The customers.
The customers. So if you enter into one ecosystem, the likelihood is you will not get out. You will, if you book your flight, you will book your hotel, you will book your car, you will book basically everything you want to book within the same ecosystem. So it's important to attract you there, and once you're there, to keep you there. And that works. And that's the reason why you would have had, according to them, an increase in market share. So that, I think, is interesting because that is the latest of a long series of decisions, both in mergers and in antitrust, in which we develop innovation theories of harm. And innovation theories of harm have become very important, I would say even dominant in what we're doing, versus the good old price effect. Because innovation is more and more defining of competition. So it's always been, but it's a lot more today. When I was a young case handler 30-something years ago, innovation was also important in our work. But the innovation of today was shaping the competition of 10 years from now. And this is no longer the case. The innovation of today in tech is shaping the competition of in 6 months.
That's an interesting comment. Do you see that innovation issue across the board? It's not only tech, or is it primarily tech you're referring to?
No, it's across the board. It's what you see is it's tech impacting other markets as well. I mean, payments, medical services. I mean, tech is pervasive across the board.
So it's other companies in other industries maybe using tech or technology to increase their own innovation into.
Yes, and their innovation is important too, and it's also an important factor in what we're doing. There are other sectors in which innovation has always been important, like pharmaceuticals, for example.
I think it's interesting you mentioned there the company's internal documents, which are of course always very important. So a good lesson there, I think, once again.
Well, they don't have much of a choice because they need to explain to their board members the rationale for the decision. So of course, I mean, they can lie, they can conceal, but that is really not advisable. That's a very expensive infringement. So it's even more expensive in this country. You could go to jail.
Yeah.
So they normally don't do that. And of course, pre-merger explanations to the board are a lot more credible than post-mergers justifications to the authority.
Yeah, absolutely. Director-General, let's move on and look ahead. So leaving aside tech, looking over the next 2 to 3 years, what are the main issues or priorities that DG Comp is likely to focus on?
Well, the first one follows directly from what I've just said. I mean, we will continue to work on innovation theories of harm in mergers, but also in antitrust. This is a very important part of what we're doing in antitrust, I mean, in tech and outside of tech. And also in something that's not of much interest here in the US, but the state aids as also an increasing innovation side. The second thing we're going to focus on is in order to be able to implement a rule, we need a main regulation. It's called Regulation 1. And this is the regulation that defines our power, our processes, the different types of decisions, etc. So it's a very important regulation. It's actually the core of what we're doing. And Regulation 1, we celebrated the 20 years last year. I told me, well, by my standard, 20 years is very young. But for a regulation in these days of constant innovation, it's quite old. Because I remember when we conceived Regulation 1, it was revolutionary at the time, but it is conceived for a paper-based world. So the first thing is we need to adapt it to a paperless world. People telework, so the ability to downrate private homes becomes more and more important. They don't necessarily telework on a computer of the office. Sometimes yes, sometimes no. Sometimes they telework on their private phone and whatever. So you need to be able to access to these devices as well. They store in the cloud, and the cloud is not necessarily located in your jurisdiction, etc., etc., etc. Then you have a number of issues that we need to address, plus a number of others, like how do you deal with rejection of complaints, which is for the time being a major source of use of our resources, and we prepare to have our resources dedicated to investigating cases than rejecting complaints without foundations. So there is a bunch of things that need to be done. So that's very important, certainly for us and also for the practitioners. The second thing is we will adapt our Article 102 guidelines, or guidelines on the abuse of dominant position. And that is because in the late 90s, beginning 2000, the way we were implementing Article 102 was really rules-based. There's a lot of per se. I mean, if you're dominant and you do this, it's wrong, period. And in the 2000s, we thought, okay, well, I mean, why is it that it's good to have more economic analysis everywhere, but in this field? So we wanted to move the goalpost towards a standard for Article 102 infringement of at least potential impact on competition that you can credibly demonstrate. Maybe you could still have some per se things. I mean, I think about a real case in which a company that has a monopoly in the market nonetheless forces its client to sign exclusivity agreement. So you may wonder why. Do you really need to have a study on the impact of this and demonstrate that it has economic impact? Actually, probably has not today. But the reason why they do this is very clear, is they want to protect themselves while they have the technological edge against any possible disruption. So they lock in the consumers. Maybe you don't need a lot of economic analysis to say that this is wrong. But in general, it's better to demonstrate that at least the practice could have a detrimental impact on the market. And that's why we put forward in 2008 a guidance paper in order to give a signal to the market. And this is something we don't do in general in Europe. I mean, here in the US, guidelines are declaratory. Guidelines are about explaining the view of the government to the judges. Because we take our own decision, we don't litigate our decisions in court. Guidelines in Europe are usually wrapping up 10 years of enforcement and court cases, and on explaining what it means in context and trying to explain what it means for the future. The 2008 paper was different. It was American-like, if you want. It was signaling a change in the policy without having much practice. Of course, for that reason, as usual in this type of case, when you practice, you see that a number of things you foresaw in the guidelines actually never happen. A number of things that happen you never foresaw. And the judges are here to tell you, well, here you were right, here you were wrong, here you should have done it a bit differently. So it's time now, 15 years later, to wrap up and issue traditional guidelines and say, well, we have had 25 decisions, 30 cases in court since 2008. Let's see what they tell us and make them guidelines for the future. So that is really something which I think is going to be...
And that'll be a very important document, as you say. It pulls together with a lot of dense footnotes, at least in the draft, all of the cases that have happened, as you say, in the past period, becoming an important document, and also the Regulation 1 2003 review on the procedural side, clearly important as well. It's similar, or along similar lines to the 102 guidelines you mentioned. There's a lot of discussion earlier this year about the scope of competition law. And you've made comments about this as well, whether competition law in the EU should or should not stay in its lane or should not step out of its core mandate, and how those two issues relate. and there was a kind of maybe a bit of a silly spat with a comment about a side dish, competition law being a side dish
gate.
Right. So how do you see this discussion about competition law being used out of its core mandate and whether or not it should stay in its lane? Because that's similar to this issue about 102 with the move from kind of rules-based to effects-based, and can competition law go even beyond what that type of analysis?
Well, I think, you have this rule in economy, I mean, actually it was even a Nobel Prize, that it's best to not assign too many objectives to one single instrument. And I think it's a very good rule, because normally what happens if you don't do that is you're likely to miss all of your objectives. So my view is always been, and is still today, that it's difficult enough to do your job in the line. My view is that for the last 25 years, we were pretty much alone in the world trying to do the job in the line properly, particularly in tech. We were criticized everywhere, in this country as well. You're too interventionist, you're crazy, etc., etc. What do we see? We see 20 years later, we see that concentration levels have raised everywhere. They have raised more in this country than elsewhere, more than in the EU, but they have raised as well in the EU. We see that this raise in concentration levels is associated with raised in markup in margins and prices. So I think that there is a lot to do in the line, in the core business. So that's my first point. So I think that before seeing whether we can turn competition policy into a sword to crusade for fundamental rights or whatever, let's try simply to make it having competition in the market and an effective competition that works. That would already be great, frankly. So that's my first consideration on this. The second consideration is that because we've been enforcing quite strongly in both antitrust and merger in the last 20 years, we don't feel the need for a huge correction, of course. And I understand that other jurisdictions that have been enforcing a lot less feel the need for a stronger correction, and I think that's welcome. I mean, I'm quite happy that we are not alone anymore. I'm quite happy, to be frank with you, with the new course of this administration in terms of how they approach antitrust and mergers. Because we have a degree of convergence we have not had for the last 20 years with the US.
And you're seeing other jurisdictions, for example, following the DMA type approach as well, or at least proposing that kind of thing.
Yeah, as well. Well, the DMA is not a blueprint for everybody. It's a system that works well, we think, in the European context.
Yeah.
It may well be that other approaches are more effective in other contexts. So
in terms of competition enforcement, you're saying that there's no need for a big change or a big inflection. Do you think the Commission has its suitable tools? There have been some comments about a market investigation type tool like there is, for example, in the UK, which has even greater powers.
Well, that's a difficult question. On the one hand, yes, I mean, I'm an enforcer, I always like to have more power. On the other hand, I don't know if you've read this book or saw the movie Minority Report.
Yeah.
But, so you put people in jail before they have committed the crime. Well, that's a bit the new competition tool now. So there is no infringement. Nobody has committed an abuse of dominant positions. There is no cartel-like agreement. But you're unhappy with the way the market functions, basically. And therefore, you take actions with coercive powers. I don't say it's illegitimate. I'd simply say
to be very careful.
You're in a different environment, let's put it that way. Yeah. Secondly, at least in Europe, but I think elsewhere, we are in a context of huge budgetary constraints. I have been given two new tools. I just talked about it, the DMA and the FSR. Very intensive in manforce. For the DMA, a headcount of 80 staff was foreseen by the legislators. For the SFR, 140. Altogether, 220. How much did we get? 20. So we're short of 200 staff for this. Yet, we enforced the two things. Because we redeployed, we stopped doing other things, but
which is not necessarily ideal.
No, it's not ideal at all, because these things have a cost. So, back to the new competition tool. I'm on the record having said that, as I know I will not have one single staff more, I don't want this power. Because if I have this power, there will be a huge pressure to use it. That means that I will have to take the decision to remove people that are enforcing in actual cases against companies that are trespassing the law with actual detriments to consumers and competitors in order to be able to take care of imperfect market structures. And I think it would be very good to take care of imperfect market structures if that would not come to the detriment of actual enforcement.
Well, that's a very interesting insight into your thinking and how in practice, you have to prioritize your work, of course. I wanted to ask you something. I see you made a comment at one point, this is on a completely different subject, in the area of enforcement against cartels. You mentioned significant investment within the Commission in relation to identifying cartels on the dark web.
Yeah.
Is that something that is bearing fruit, or is something you felt was you were pushed into because of how these things are operating?
Well, both. No, when I came back in 2020, I have to disclose my biases. When I left DigiComp in 2010, I was the director for cartels. So I have kind of a soft spot. And when I came back in 2020, I saw what had happened everywhere in the world, and that was the case in the Commission as well, which is a pipeline of immunity cases slowly drying out. And of course, that was entirely predictable. I had actually predicted it before I left. And that's why one of my last decisions before I left the Cartel Directorate was to dedicate a third of the staffing to non-immunity cases, ex officios, in order to maintain a credible threat to be detected. Well, my successors chose that it was a lot easier to process leniencies. They came back on that decision, and when I arrived, there was no pipeline.
Is that because of the damages directive principally? Is that your...
Well, I never thought so. I think it's because we stopped to invest into ex officio cases. And actually, a lot of people made the same remark as you. Why do you bother? Just get rid of the damages directive. I never believed that was really the issue. And we have a natural experiment. In the US, you detribbled. I'm not aware that generated a flood of immunity applications to the DOJ. So that means that the sensitivity to this of parties is not great, but the sensitivity to the threat of being detected is far greater. And we have also a natural experiment. So when I arrived, one of the first things I did was to appoint a new director for cartels, Mrs. Jaspers. I knew her because I had worked with her when I was myself director for cartels, and she had only one mandate: rebuild the pipeline, which she did. So dark web is part of this, but it's not only this. It's also maintaining a constant network and relationship with a network of whistleblowers. It's also investing into IT tools in order to recognize quickly patterns on both public and private databases, including by web scratching. It's a number of things, including things I will not tell you. And anyway, the net result 4 years down the road is we have rebuilt the pipeline. 1 out of 2 cases that we are processing at the moment are not generated by an immunity application. And guess what happened? For the last 2 years, the number of immunity applications is on the rise. And they're directly connected to the ex officios. Because what you do when you have more ex officio, people start to think, oh God, they're back. Yeah. So my chances to be detected is higher. And you start to wonder and you start to run to confess before anybody else does it.
Destabilizes the
and you're back to the good old dynamics.
Do you feel the Commission has the resources and the personnel to continue with that kind of work on the tech side? I know you're still looking for a CTO at the moment.
I've not yet had time to look at the list. It's in my mailbox. The application period has closed last week. Yes, I mean, well, certainly I am making choices. That's part of my job as Director-General. And one of the choices I've made was not to undermine the cartel activity. So, with all the competing things like DMA, etc., taking a few more people out of the cartels could have been the easy way. Because this is the type of thing that doesn't show immediately. It shows in 5 years. And in 5 years, I don't know what I will be doing, but I will probably not be Director-General for competition. But that's not the way I work. I think it's important to have a long-term perspective and to make long-term investments in this type of activities.
And your successor will hopefully...
I hope he will appreciate.
Well. He or she will be pleased as well. Final substantive discussion, please. Looking at AI and cloud computing issues specifically, what do you see as the main competition issues and tools that can be used to deal with those?
Okay. That's a complicated question. There is a simple part of it, which is what we're currently doing. And that is, how does AI impact existing markets and services and activities? And for this, that has consequences in our antitrust activity, but also on our DMA activity. When you are looking at the situation or the gatekeeping functions in, say, for example, search engine, the irruption of AI in the search engine service is certainly extremely relevant. It has consequences. It needs to be taken into account, analyzed, etc. Sure, it could be pro-competitive or anti-competitive, depending on the situation. So that we do, and it's relatively traditional. The second issue is about, still in antitrust and DMA, AI as such. AI as a market or a service or whatever. And that is, of course, more complicated because it's nascent. But we have learned, of course, over the last 25 years, that what is nascent today can be tipping in 6 months. And when it will tip, it will tip super quickly. So for the time being, you have this mushrooming, you have OpenAI, you have Mistral, you have a number of others. You have very wealthy people and companies that are putting their money a bit everywhere. But at some point, there will be a winner. And the winner takes it all, at least historically in tech markets.
Do you think that's necessarily the case in this area? Because, of course, these are not typical platforms. They're kind of business to business up and down the chain with maybe a platform at the end. But certainly Microsoft, for example, has said that this isn't necessarily the same as the, if you like, old-style digital tipping markets.
And that's true. It's, in many aspects, completely new. So we don't know. But we don't want to take the risk. Maybe it will be the way Microsoft thinks it will develop, so you will have a world of competing AIs, and maybe not. Certainly given the investments that are necessary to, train an AI really meaningfully, and the type of competitive advantage that you will have if you are the one that is flawless. So because we don't know, we monitor. But there's nothing much more that we could do at the moment. But some people tell me, why don't you designate gatekeepers in AI? Well, where is the platform? It doesn't
it's
fit.
It's not currently covered by the DMA, is it?
But it couldn't be. Even if we covered it, what would we do? Who would we designate? For what? So, we are at this point in which things are in the making. And I don't think we have any standard to intervene at this stage. Because I'm a competition person, so I'm not in favor of picking the winners so you need to have this Darwinist process to happen, and maybe at some point we'll need to intervene. The only thing we know is that if this is the case, we will have very little time to make up our mind, which is why we're trying to evaluate all the possible options, the market developments already know, in order to have already conceptual frameworks when the day comes.
On two specific points within that area, there's been a lot of discussion recently about big tech, for example, Microsoft, hiring employees, sometimes en masse, out of startups in the AI or cloud sector, and also a lot of minority investments and partnerships. Can you talk about what tools you are currently or thinking about using in order to deal with those two specific issues?
Well, the first one, I suppose you refer to OpenAI and Microsoft. We're studying it. It's ongoing, so we'll not make comments.
Can you say in principle what types
Well, in principle is the merger regulation that it does. So the question is, does it amount to Microsoft controlling OpenAI or not? The only thing that I can say is that, on the one hand, control through a variety of means, including economic influence, is not unprecedented. We have cases. But on the other hand, there are obviously much more complex and difficult cases to make that a straight majority shareholding. So we're looking at it at the moment. The cases of poaching smaller competitors' employees is more complicated. Because on the one hand, we have a number of cases against no poach agreement. So poaching is competition. Is the fact when you are Microsoft poach the best assets of smaller competitors or small innovative companies, let's put it that way, amounting to an abuse of its dominant position? That would be a difficult case to make in European law, at least, frankly.
Because certainly at the moment, in particular, for example, in cloud or AI, whoever defined, there wouldn't be such a position.
Yeah.
Even if you could find an abuse.
Yes, and cloud is different than AI. In cloud, Microsoft has built, at least in Europe, a significant position. Whether it's dominant or not, I don't know. But AI is really in the infancy of the problem.
As you say, the CMA, on that point, the CMA in an initial report on foundation models found that there have been no fewer than 160 AI foundation models released since 2018, so it's a pretty diffuse market.
Yeah, the September report, the CMA, is extremely interesting. I think they should be commended for that. I mean, they're ahead of everybody else in the world on this. We have used their work ourselves. We have now taken ourselves, as you know, a number of initiatives in order to complement or information, I would say, on this. We have published a call for contribution a few months ago on competition and generative AI. We have sent requests for information to a dozen of large companies to look into whether any of their agreements and partnerships with generative AI developers may raise any potential competitive concerns. And we're, of course, checking Microsoft's on OpenAI. So the results of the study we think we will have at the beginning of the summer. I know that our British friends are continuing to work on deepen their understanding. And at some point, we are talking with each other, of course, and with the American colleagues. And at some point, I think we will wrap up and see what we have and where to go from there. I mean, I think this is really an area in which there is no other choice but to be joined up.
Even closer cooperation than
for anything else, yes.
And then finally on this, I guess, from what you're saying, it sounds like interim measures against some of these activities, which is, of course, very unusual in EU antitrust, is certainly on the table.
Yes, it is unusual, you're right. We used it once in the last 25 years, so unusual is the right word. I would like that we use it more. And I talked about the revision of Reg 1. That's also one of the things we will have to look at in that respect. But it's indeed under the table for one reason, which is that, as we saw in the Broadcom case, the case in which we used it, what is really interesting with interim measures is that changes completely the incentive games. So in a normal antitrust case, the incentive of the parties is to slow down everything. In particular in tech, because as the network effect is so powerful, if you slow down the investigation, you will have killed everybody on the market.
It's been part of the strategy, hasn't it?
Of course it is. So what you do if you have interim measures is you freeze. They cannot deploy their measure anymore. And all of a sudden they have the kind of incentive they have in a merger rather than the traditional incentive they have in... and it's really funny because you see the same lawyers that are Ferraris in a merger and turtles in an antitrust case. Well, all of a sudden they prove that they can be Ferraris in antitrust as well. And I think we should have more of this.
Makes sense. Thank you very much, Director-General. It's been a very extremely interesting conversation. Just ask you a final personal question. Will you be attending any events at the Olympics, which is, of course, Paris 2024? I know you're a rugby fan. Will you going to the Rugby Sevens?
Yes.
Very good. Personally, I'm looking forward to seeing a basketball game in Lyon.
Well, yeah, I'm not a big on basket, but it will be great anyway. But yes, I will be. I have the men and the women on Rugby 7.
Excellent. Thank you very much.
You're welcome.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.